Right now, there's a story spreading fast that sounds exciting, almost too exciting. The claim is that a sudden Supreme Court move has just wiped out assault weapon bans across the entire country, and if you take that claim at face value, if you don't slow down and understand what actually happened, you could end up making a decision that follows you for the rest of your life. Before we go any further, pause for a second. Ask yourself this: do you really want to trust your freedom to a headline designed to get clicks? Because what I'm about to explain isn't about hype. It's about reality, and reality is what courts enforce, not thumbnails. Let's talk like real people for a moment. The word Supreme Court and emergency action triggers something automatic in our brains. We hear that combination and think the fight is over. That someone up there made a final call and everything changed overnight. That reaction is normal, but it's also wrong more often than not. Emergency actions by the Supreme Court are not the same thing as final decisions. They don't usually rewrite the law. They don't usually settle constitutional questions. And they definitely don't give you a free pass to ignore your state's statutes tomorrow morning. What most people don't understand is that when the Supreme Court steps in on an emergency basis, it's usually not deciding who wins. It's deciding whether to press pause. That pause can matter. Sometimes it matters a lot. But a pause is not the end of the game. It's more like telling everyone to stop moving while the referees figure out what happens next. The scoreboard doesn't reset. The rules don't disappear. Everything just freezes for a moment, and even that freeze can be limited, narrow, and temporary. Here's the bigger picture that rarely makes it into viral clips. Across the country, there are multiple legal battles happening at the same time over firearm regulations. Some cases challenge rifle bans based on features. Some focus on magazines. Some deal with registration schemes. Others argue over how far states can go without violating constitutional protections. These cases are scattered across different courts, moving at different speeds, under different judges, with different records. Most of them are not at the finish line. Many of them aren't even close. A lot of these lawsuits are stuck in the early phase where one side is asking for a temporary block. This is called a preliminary injunction. That's legal language. But the idea is simple. One side goes to a judge and says, "We think this law is unconstitutional, and while we argue about it, we want you to stop it from being enforced right now." Judges don't grant that kind of request lightly. They apply a specific test. They look at whether the challengers are likely to win in the end, whether they'll suffer serious harm if the law stays in place, and whether blocking the law would cause harm to the public. That last part is where things get complicated. Even if a judge thinks a law might be unconstitutional someday, they can still refuse to block it immediately if they believe stopping enforcement right now could cause problems, or if the evidence hasn't been fully developed. That means you can have a situation where a court says, "We're not convinced enough yet to freeze this," without saying the law is valid forever. It's not a loss, but it's also not a win. It's legal limbo. Now let's talk about one of the most misunderstood words in all of this: stay. A stay is nothing more than a pause. Depending on the situation, it can pause a lower court's ruling, pause enforcement of a law, or pause part of a case while something else happens. When the Supreme Court issues a stay on an emergency basis, it is almost always temporary. It's not a declaration that the Constitution has been interpreted one way or another. It's a procedural move meant to preserve the status quo while the court decides what to do next. So when someone tells you that an emergency Supreme Court move has ended assault weapon bans everywhere, the first thing you should ask is very simple. Did the court actually decide a constitutional question? Or did it just adjust the timing of enforcement in one specific case? Because those two things are worlds apart. Timing decisions don't give you nationwide permission to ignore your local law. This matters because the real world doesn't operate on internet excitement. It operates on what's written in statute books and what police, prosecutors, and judges are told to enforce today. Imagine living in a state with strict firearm regulations. You see a video claiming everything just changed. You believe it. You decide to buy something that was banned the day before. Or you order it online thinking you can cancel if there's an issue. Or you take something out of storage and transport it differently than you used to. Maybe you even post about it because you think you're celebrating a legal victory. Then one ordinary day, you get stopped for something small, a light out, a minor traffic issue, nothing serious. Suddenly you're standing on the side of the road, trying to explain that you heard the Supreme Court fixed everything. The officer isn't debating constitutional theory with you. they're enforcing the law as it exists. Right now, this is how regular people end up facing charges they never intended to risk. Not because they were reckless, but because they trusted noise instead of documentation. This is why it's dangerous to confuse excitement with accuracy. There are creators who thrive on urgency. They want you scared or thrilled or angry. Because emotional people click faster than careful people, calm verification doesn't go viral. Panic does, celebration does, and the price for being wrong doesn't land on the person who posted the video. It lands on you. So let's slow this down and make it practical. Emergency Supreme Court actions exist because sometimes waiting months or years would cause real harm. When one side believes that's happening, they can ask the court to step in immediately. The court might agree, but even when it does, it often issues a very short order with little explanation. That lack of detail creates chaos. Everyone fills in the blanks with whatever version helps. Their argument or their channel dot an emergency order can absolutely have an immediate effect in one place. If the court tells a state to stop enforcing a specific provision while the case continues, that state may have to comply. That's real. But that doesn't automatically mean every similar law in every OT. Her state just vanished. Temporary relief in one case does not always bind everyone else, especially when the court hasn't resolved the underlying constitutional question. This is where the word nationwide gets abused. Sometimes a Supreme Court decision truly is nationwide, but that usually comes from a full opinion after full briefing and argument. Emergency orders are different. They are often narrow, cautious, and limited to the circumstances of one case. Calling them nationwide is often marketing, not law. Another common trick is taking a development in one state and pretending it applies everywhere. Even if the states have similar laws, relief in one doesn't automatically transfer to the other. Unless the court explicitly says so, legal systems don't work on vibes or similarities. They work on jurisdiction, language, and scope. The reason this area is such a mess is because courts are still wrestling with core questions. Are certain firearms protected arms? If so, how much regulation is allowed? What does common use really mean? Is it about how many exist, how many people own them, or how they're typically used? Courts disagree, lawyers fight over data, experts argue, judges weigh history and precedent. It's slow, technical, and nothing like a breaking news alert. While all of that grinds forward, people want instant clarity, so every procedural move gets treated like a final verdict. But most of the time, it isn't. It's just another step in a long process. Here's the practical rule that keeps people safe. If you live in a state with restrictions, do not assume anything changed unless you can point to a specific court order that applies to your state and your situation, and even then, read it carefully. Some orders only protect certain plaintiffs. Some block sales, but not possession. Some pause enforcement temporarily. Some apply only within a specific judicial district. Missing those details is how people get hurt real-world situations. Someone owns a firearm that was legal when purchased, but later restricted. The state allows continued ownership under strict rules. A headline appears claiming everything is over. That person stops following those rules. They lend the item, transfer it improperly, or move it across state lines casually. The law didn't change. The misunderstanding becomes a felony. Another person lives under magazine restrictions. They hear about a case involving rifles and assume it covers everything. They order magazines thinking the Supreme Court cleared the path, but the case didn't address magazines at all, or only address sales, not possession. The result is charges that could have been avoided with 10 minutes of verification. Travel creates even more risk. Different states treat similar items very differently. Assuming national uniformity where none exists is a fast way to end up dealing with another state's criminal system. Even if charges are later dropped, the process itself is punishment. Lawyers, court dates, missed work, stress, reputational damage. That's a heavy price for trusting a shortcut. One of the biggest myths floating around is that once the Supreme Court agrees to hear a case, the law disappears. That's not how it works. Agreeing to hear a case just means the court is willing to listen. The law usually stays in effect unless there's a separate order blocking it. Months can pass before a decision comes down. Acting early doesn't make you brave. It makes you vulnerable. Even in a scenario where a major decision eventually favors gun owners, states often respond quickly. They adjust definitions. They create new licensing systems. They add procedural hurdles. Legal battles don't end cleanly, they evolve. Staying informed isn't optional if you want to stay lawful. This isn't legal advice, it's education. Your specific situation always deserves professional guidance, but there is a simple personal checklist that works. Don't change your behavior because of a headline. Find the actual court document. Confirm it applies to your state. Confirm what it actually blocks. If there's any doubt, assume the law is still enforceable and act accordingly. The mistake that destroys lives is acting like you want to be the test case. Most people don't. They have families, jobs, and responsibilities. Turning yourself into an example doesn't help anyone, especially if you're wrong. If an emergency Supreme Court action disfavor gun owners, treat it like a surgical instruction, not a blanket pardon. Understand exactly what enforcement is paused and what isn't. Police authority, prosecution authority, sales rules, possession rules, and carry rules are not interchangeable. Confusing them is dangerous. The reason nationwide gets thrown around so much is simple. It makes people feel included. It makes the story feel big. But unless there's a final opinion establishing a clear rule, it's often premature. Emergency actions affect the short term. Final decisions shape the future. Imagine the states with similar bans. One gets temporary relief, the other does not. That's entirely possible. Relief doesn't spread automatically. Courts don't operate on sympathy. They operate on orders. Even if a major ruling eventually strikes down certain bans, there will still be confusion, reinterpretation, and resistance. That's how legal systems work. That's why patience matters. For anyone feeling exhausted by all this, that reaction makes sense. The law is complicated. The answer really does depend on where you live and what you own. But here's a rule that holds. If you cannot show a clear, binding order that protects you, behave as if the restriction still exists. Verify before you buy, move, travel, or transfer. Think in terms of risk, not news. What does your law say today? What's the penalty if you're wrong? What proof are you relying on? A document or a rumor? Watch for 3 things going forward. Clear emergency orders that explain what's paused. Announcements that the court agreed to hear a case. And final opinions that address the issue directly. Everything else is commentary. No future victory is worth catching charges in the meantime. The smartest people in this space don't chase drama. They chase clarity. Imagine a traffic stop. An officer asks a question. They see something your state still considers restricted. Saying the Supreme Court fixed it doesn't change what's enforceable in that moment. Even if the law changes later, that moment can still cost you dearly. Emergency Supreme Court actions are not magic. Pauses are not victories. Headlines are not law. Your freedom depends on what applies today, not what might apply someday. If you want truth without hype, always check the source, read the order, and understand the limits. It's far better to be cautious and boring than confident and wrong.